The common law has long offered ample protections even for reasonable mistakes. By the way, statutory law does the same thing. So you're not required to make perfect decisions in self-defense. That's what the whole notion of reasonableness is about. You're required to make reasonable decisions, but you're allowed to make mistakes. Mistakes of fact, not mistakes of law. Mistakes of law, that's on you, right? Ignorance of the law is no excuse. But you're allowed to make mistakes of fact. So someone points a gun at you and you draw your own gun and you shoot them dead because you were defending against what you reasonably perceive to be an imminent threat of deadly, unlawful harm. And it turns out their gun was a prop, a fake, a non-functional imitation of a gun. So it did not actually present a deadly force threat to you. There was no way you could have been shot by that inanimate object. You made a mistake. You perceived an inanimate object as being a real gun, and you were wrong. You were mistaken. Does that diminish your privilege of self-defense? No. No, so long as your mistake was a reasonable one. So long as your perception of that as a firearm was a reasonable perception. This is true under common law. It's true under all self-defense, statutory self-defense too. That's the legal standard. Reasonableness is enough. You're allowed to make mistakes in self-defense as long as they are reasonable mistakes. All right, so the common law has long offered ample protections even for reasonable mistakes. These laws are based on an urban legend that people are routinely prosecuted for defending their homes from intruders. I don't know why that's an urban legend. It certainly happens. It's happening here. In this case, this defendant here, Drezalowski, is going to say, I was defending my property. And he's being criminally charged. He's being prosecuted for defending his home. The laws have produced perverse results. Okay, so these laws, and I think he's trying to refer to this collective conflated phrase he's been using, Castle Doctrine or Make My Day. These Castle Doctrine or Make My Day laws are based on an urban legend that people are routinely prosecuted for defending their homes from intruders. Why should they ever be prosecuted for defending their homes from intruders? If it happens once, isn't that too much? Doesn't that make these laws? I mean, the notion that these laws were fabricated out of whole cloth without any apparent necessity perceived by the legislature, I don't know, that doesn't seem very sensible to me. The laws have produced perverse results, as in the controversial case of Tom Horn in Texas. Okay, I guess I have to look. What is the controversial case of Tom Horn? Okay, so Tom Horn shot two people breaking into his neighbor's house. The case has focused on Make My Day laws. Again, no, or the Castle Doctrine. Again, Professor Charlie's using these as synonyms for each other. They're just not. And Castle Doctrine would have no application to defending a neighbor's home when you're in your own home. First of all, there's no... Why would you need to be relieved of an otherwise existing duty to retreat? Now, I think what he's doing here is he's conflating Castle Doctrine with things like a legal presumption that an intruder in your home is presenting as a deadly force threat. That's a different legal doctrine than Castle Doctrine. Let's go back to his article here. And boy, the fact that results may be perverse or controversial, that's not legal argument. That's media argument. Right? Lots of cases are controversial. George Zimmerman was controversial. Kyle Rittenhouse was controversial. The legal issues in neither of those cases were complex. The black letter of use of force law was very clear in both those cases. So the media can make anything controversial. That doesn't mean what's happening is legally unsound or that the doctrines are sketchy. Let's see. Yet the popularity of these laws have spawned Make My Day Better laws. Make My Day Better. I think he just means Make My Day laws that extend the privilege of lethal force to businesses and cars. Okay, again, this is something else. Make my day is the Colorado law that took away the requirement of proportionality if you meet the conditions of that statute for defense against an intruder in your home. Extending special privileges for the use of deadly force in defense of highly defensible property, like your home. Your home is always included as highly defensible property. Some states expand the definition of highly defensible property to your business and to your car. So the same legal presumption of a reasonable fear of deadly force harm when you're defending against an intruder in your home would apply to that intruder in your business or that intruder into your occupied car. But that's still not make my day. That's just the legal presumption of reasonable fear being expanded beyond the confines of your home. It's an expansion of the definition of highly defensible property. Florida is a castle doctrine state as well as a stand your ground state. All right, so what did we talk about with castle doctrine? Castle doctrine, if you would have had a legal duty to retreat outside your home, you're relieved of that duty inside your home. Stand your ground says you don't have a legal duty to retreat outside your home in an otherwise lawful case of self-defense if you meet the conditions of the stand your ground statute. Now, if you meet the conditions of stand your ground, and typically you're not engaged in unlawful activity and you're in a place you have a right to be, you're not trespassing, you're not acting in a criminal manner, then you don't have a legal duty to retreat anywhere. Avoidance is waived everywhere under stand your ground in an otherwise lawful case of self-defense. But if stand your ground applies, you don't need castle doctrine, because if you wouldn't have a legal duty to retreat out in the public street, you certainly don't have that legal duty in your home, independent of castle doctrine. Stand your ground doesn't say this only applies outside of your home and you have to rely on castle doctrine inside your home. Stand your ground largely makes castle doctrine irrelevant. The only exception would be edge cases where you may not qualify for stand your ground outside your home because you are, for example, engaged in illegal activity. Say you're transporting contraband, illicit drugs. The prosecutor could argue, well, he was engaged in drug dealing. That's an unlawful activity. He doesn't qualify for stand your ground. But castle doctrine doesn't have not being engaged in unlawful activity as a requirement. The only requirement is that you're in your castle. You could be in your castle, engaged in unlawful activity, and you still get the benefit of castle doctrine. You still are relieved of that otherwise existing legal duty to retreat. Now, there are these other legal provisions, like the legal presumption of a reasonable fear of deadly force harm from an intruder. I call those defensive, highly defensible property statutes, not castle doctrine. Castle doctrine is different. Those other statutes, a legal presumption of reasonable fear from an intruder, those are often conditioned on you not being engaged in illegal activity or using the property for illegal purposes, like drug dealing. So you could lose the legal presumption that you had a reasonable fear of death. You don't lose self-defense generally. It's just you don't get the benefit of the legal presumption that the elements of self-defense have been satisfied. And you don't lose castle doctrine. So again, these are all different things. Florida is a castle doctrine state. And of course, this shooting over the tree trimming happened in Florida, to remind you. Florida is a castle doctrine state as well as a stand your ground state. That could factor heavily into the criminal investigation. Maybe not. The only way it would factor in, well, first of all, there would have had to have been a completely safe avenue of retreat in the first place. Because if there isn't a completely safe avenue of retreat, there's no legal duty. You're not required to increase your jeopardy to try to escape the threat before you can lawfully defend yourself. So the first question is, well, would completely safe retreat have been possible once the threat with the chainsaw was made? I mean, this defendant does not look like a spring chicken. What did they say? He was 78? How fast is he going to run at 78 from a 42-year-old? Wielding a chainsaw. So his reach is what? Another 2-3 feet out from the end of his hand. So I would suggest it's unlikely, unless there was really substantial distance between them, that a completely safe avenue of retreat existed at all. And in that case, there's no legal duty existing to try to retreat, and both stand your ground and castle doctrine become irrelevant, because all either one of those does is deal with that legal duty to retreat, deal with the element of avoidance. That's it.